The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. There are three cases will be submitted this morning. Those cases are Robert Allen Barker versus Donald Capotosto and Thomas McGee. Second case is Tina Elizabeth Lee versus State of Iowa and Polk County Clerk of Court. The final case is State of Iowa versus Joshua Scott Pearson. The last case is now submitted to the court as non-oral, and we'll hear the arguments in the Barker matter. Ms. O'Connell.
May it please the court. Counsel. To administer justice according to law, equally for all people. This is a stated mission of the Iowa Judicial Branch, to administer justice equally to all people. Today we ask the court to do just that. We ask the court to reject the imposition of a nearly insurmountable hurdle being placed before a class of disfavored litigants trying to get their day in court. As a brief summary of the pertinent facts of this case, the appellant, Mr. Robert Allen Barker, engaged in an online conversation with a person he believed to be a 15-year-old boy. The person he was actually communicating with was a special agent conducting a criminal investigation. After Mr. Barker made arrangements to meet with the boy for sexual purposes, he was arrested. Mr. Barker was initially charged with 2 counts. The first count was enticement of a minor for an illegal act, and the second count was lascivious acts with a child. The state later amended the second count from lascivious acts with a child to solicitation of a 15-year-old to engage in a sex act. Mr. Barker was initially represented by one of the appellees, Mr. Thomas McGee. After consultation with Mr. McGee and on the advice of his counsel, Mr. Barker executed a written plea of guilty to count 2, solicitation of a 15-year-old to engage in a sex act. Mr. McGee was then permitted to withdraw as Mr. Barker's counsel, and Mr. Donald Capotosto, the other appellee in this matter, was appointed to take over Mr. Barker's representation. With Mr. Capotosto present, Mr. Barker entered his oral plea of guilty on the record to solicitation of a 15-year-old to engage in a sex act and was sentenced for that offense. 3 years later, Mr. Barker filed an application for post-conviction relief. He alleged both that there was not a sufficient factual basis for the plea that he entered and also ineffective assistance of counsel. Mr. Barker's application for post-conviction relief was sustained. After receiving post-conviction exoneration, Mr. Barker filed the present legal malpractice action, which I will often refer to as a criminal malpractice action, against his defense attorneys.
Sorry, I need to turn my microphone on. I take it you concede he was engaged in illegal conduct.
That is correct, Your Honor. It is undisputed that Mr. Barker engaged in conduct that would have been deemed an attempted enticement of a minor, so a lesser included offense to the first count charged.
All right, so I think the argument that's advanced by opposing counsel is why should there be a recovery arising out of a transaction which was admittedly criminal in nature?
Yes. Well, Your Honor, I mean, there are 3 primary reasons that we're requesting that the actual innocence standard element be rejected. That's the public policy, including that a criminal should not be able to profit from his own conduct. It's fundamentally flawed in its logic. There are also more fundamental interests that are better served by rejecting the actual innocence standard, and the element of causation sufficiently addresses the proper policy considerations.
Okay, so what are the elements of causation that you think you need to prove?
Well, with respect to causation in the typical civil legal malpractice case, there's obviously but for and then the scope of liability causation. In the civil legal malpractice context, that requires the case within a case, if you will. We posit that that case within a case could acceptably be transferred to the criminal malpractice arena.
If you transfer that case within a case, I mean, if he's not guilty of enticing a minor, but maybe if the jury would find that he could have been found beyond a reasonable doubt guilty of attempting to entice a minor, does that go to the damage issue, or does that go to the duty issue, the liability issue?
Your Honor, I think that it would go to the causation and damages issue. The duty issue, due to the post-conviction exoneration requirement that this court adopted in Troba versus Sondag, the criminal malpractice plaintiff has to already prove exoneration. He has to already prove that he was materially prejudiced by conduct.
Well, what would the measure of damage would be? Let's say that you brought this case and were able to prove it, and you proved that, you know, he did not commit enticing a minor, but the jury believed he attempted to entice a minor. What's your measure of damages?
Your Honor, the measure of damages is the loss of liberty that this criminal malpractice plaintiff has sustained.
How do you prove the difference between the two? I mean, tell me how you do it. You know, in a civil suit, you get money. I mean,
Right.
we could talk theoretically about all this stuff, but
Sure.
What would be the monetary damages in that type of case? I mean,
Sure.
how would you measure them?
Well, loss of liberty could be measured not only by the potential monetary costs or what that defendant was not able to earn while he was incarcerated, and also intangible potentially damages.
How do you prove the incarceration would have been different in the attempted versus the crime itself?
Well, Your Honor, I think I'm somewhat confused because the attempted, the lesser included offense, that is, I mean, we are admitting that he was or could have been found guilty of that charge. He was not. That charge was dropped. And that is a part of this issue. It is if the court would accept an actual innocence requirement, how far does the court go in requiring actual innocence be proven?
How do you prove a case within a case if he was guilty of the lesser included offense?
Your Honor, I think that it is, there are circumstances in which a defense counsel's negligence could be so great compared to the guilt of the underlying offense that indeed a jury could find that that was the actual cause of the damages, the actual cause of the loss of
Well,
liberty.
in some
isn't-
cases,
Go ahead.
well, in some cases, it might be, I suppose, that the offense for which he was convicted of was maybe a felony and had a stiffer penalty regime, and the lesser included offense had a less powerful penalty regime. And perhaps, under some facts, you could prove that, you know, you couldn't have been sentenced to 15 years. Under the lesser included offense, it would have been a lesser offense, and then maybe you could prove damage. In this case, can you make that showing, however?
Well, in this case, that is a good question. In this case, first of all, and this does in some ways go to, again, the extent to which an actual innocence requirement would be adopted. If our court affirmed the district court, we would go farther than every other jurisdiction in the nation. Every other jurisdiction requires actual innocence only of the crimes of which the criminal malpractice plaintiff was adjudged guilty, whether by plea or by conviction. This was merely a charge of guilt. This opens the floodgates to the question of how many transactionally related charges must actual innocence be proved.
That's exactly the standard in the wrongful imprisonment statute, isn't it?
Your Honor, the wrongful imprisonment statute does absolutely require actual innocence. It is, however, distinguishable, I think, from the case at bar. The analogy is largely ineffective in light of the specific context in which this case arises. While certainly there is some overlap and some visceral draw to that argument or that analogy, the state only provides limited waivers of immunity under the Tort Claims Act. So it's really unsurprising that the state would limit the immunity waiver for wrongfully imprisoned persons more stringently tailor that to allow only claims in those circumstances.
Isn't there, you know, in sort of the causation network of this case, isn't there another problem that your client was also convicted separately of theft, and at the time the probation was revoked on the enticement of a minor charge, there was also around then a revocation proceeding commenced on the theft. So he would have, doesn't it seem likely, gone to prison either way?
Your Honor, those are completely separate incidents. They were not even transactionally related. And to the extent any future crime that our client had committed for which his probation was revoked.
But it goes to damages again. In a tort case, if you have a prior back injury or a subsequent back injury, it takes away from the damage you could collect from the claim you're making, because you can't collect twice for the back injury. If you're in prison anyway, I mean, how are you damaged if you're going to prison? I mean, your theory sounds, you know, theoretically okay, but when you start applying it to the real world and the damage issue, you still haven't convinced me that, you know, you can sort out the damages when you have all these other things in the background. You have a theft, a revocation, you have a lesser included charge. I mean, you can't recover for going to prison when you were going to prison anyway.
That's understood, Your Honor. And that is relevant to damages. Whatever other circumstances are going on, whether in Mr. Barker or in future criminal malpractice plaintiffs' lives, would absolutely be relevant and should be addressed in the damages stage.
Hypothetically, if we agreed with you and then the case goes forward, then it would, if the defendant or defendants could show that your client would have, the state was not going to let him out without any charge, would have required that he plead guilty or go to trial on that other Class D felony, then that would be a defense to the defendants, right?
That is theoretically possible, Your Honor, yes. Actual guilt may be relevant on a case-by-case basis to causation and to damages.
But isn't causation classically a jury question, and should we just let the jury decide all these issues about what might have happened, what would have happened?
It is, Your Honor, and that's exactly what we would propose happens, that the actual innocence standard is rejected, that additional element is rejected, and that the case is allowed to proceed to a jury on the causation and damages issue.
Well, what are you proposing to be the standard that we're supposed to adopt here as a result of this case? Again, this is a case of first impression. We've got a full range, you know, from the review of the cases as to what the standard of review should be. What do you say should be the standard that we should apply and adopt here?
Your Honor, now that Iowa has already adopted the post-conviction exoneration requirement, we propose that the state of Iowa reject the actual innocence standard, that the case proceed mirroring the civil legal malpractice elements, and that as to causation, it remains a case within a case.
Well, let me ask you this, and this is where I'm having a little bit of a problem with that, is a lot of the states have adopted this PCR as being somewhat of the gatekeeper, and as long as you've been successful on PCR, then that opens the door to this type of litigation. But I'm not really comfortable of that being the actual standard, because in this individual's case, even though he he acknowledges, I think in the briefs everybody acknowledges that he was guilty of a lesser included offense. The prosecutor in this case simply elected not to do anything further. And so now you've got a third party involved in the decision-making here, being the prosecutor. So I'm just telling you, I'm a little concerned about just saying, well, now that he's been exonerated because of this PCR decision, we still have the prosecutor, and we all know that he is guilty of some offense. How do you respond to that?
Sure. Well, I mean, Your Honor, the prosecutor's discretion in whether or not he wants to bring any additional charges after exoneration, that's, certainly something that we cannot address specifically. But the PCR does provide that bright line requirement that will and has kept frivolous cases from flooding the civil justice system. Now, to the extent that a criminal malpractice plaintiff is just fortuitous in that there has been no additional pursuing of the charges, that certainly, again, could come up presumably in the case with respect to the causation and damages. I would assume that that may be a part of the defense's case as far as whether or not Mr. Barker or whoever the criminal malpractice plaintiff is, whether their underlying conduct was a intervening and really superseding cause of damages rather than the negligence of defense counsel.
Thank you, counsel.
Thank you.
Mr. Wonio?
May it please the court, counsel, we'll try to split the time as best we can, answer the questions. In this case, Mr. Barker's got a very, very sordid issue. But what he's saying is not really, my lawyers failed me. He's saying the system failed me, and now I want money. And he consistently claimed, I'm here to take responsibility because I acted illegally. Yet he's not once done that. A few things factually that I want to...
But wait a minute, I mean, the system failed him, and part of that was the attorney. I mean, he ended up pleading guilty, and ultimately, following a revocation proceeding, was sent to prison for a non-existent crime, right? There is no crime of soliciting a minor to commit a sex act in Iowa, right? It doesn't exist.
Well, I don't know if, how do you mean it doesn't exist? I mean,
there's no such, the crime doesn't exist. There is no, the solicitation involved, this person, the minor, there was no minor, the minor was, the person was not, even if they were a minor, was not going to be committing a crime. A minor committing a sex act is not a crime. Solicitation requires that you solicit someone to commit a crime. The whole thing is non-existent, right?
Well, it's non-existent in the sense that you all haven't weighed in on it yet. It is existent, as our court indicated, the district court indicated in the PCR. There are several jurisdictions that have interpreted a very similar statute to conclude exactly that way.
I've heard, your argument might have been good maybe in '69 because when we had comparative fault, contributory negligence, if you were any at fault, you don't get anything. And that really sounds like what the actual innocence, defense is, you're at fault, you don't get anything. We now have gotten away from that, and every state has gotten away. We've got comparative fault now. We've adopted in Iowa the lost chance of survival doctrine, dealing with malpractice cases where, well, maybe what they did couldn't keep you alive for 100 years, but if it could have kept you alive for 10 years, you get the difference. I mean, it seems to me that those type doctrines, felony versus misdemeanor, time served versus time served, can all be applied to a legal malpractice case and let the jury sort it out on causation and damages. I mean, it sounds like this actual innocence standard is going back to the contributory fault era. How do you answer that?
Well, there's been a ton of ink spilled on that exact type of analysis, and the question is a court able to fashion something within four corners of an actual innocence standard that can be bright line applied to every case?
Of course, we have that with Traubach. I mean, the bright line is you must be exonerated of the underlying crime. And in Traubach, I may be mispronouncing the name, I'm doing the best I can, but
I know what you're
in Traubach, it talks about the gatekeeping function and so forth. And as I understand counsel's argument, they're not arguing that we depart from Traubach. So we have a gatekeeping function in place. I think you're arguing for an additional gatekeeping function beyond Traubach. And I'm struggling with that. I do understand there's a causation issue, of course, and I think we all understand there's a causation issue. The question is, how is that treated? And ordinarily, causation issues in a professional negligence case are matters for the jury to sort out, unless you get summary judgment on causation. Sometimes you do, pretty rare, but maybe this is conceivably the case where you might get summary judgment. But I guess my question is, we've got a gatekeeping function in place with Traubach. Why isn't allowing the fact finder to sort out all these causation issues adequate protection?
Well, in this case, because of the factual distinction that's different from the new case that they cited, Machaney, and a few of these other jurisdictions that have refused to adopt the actual innocence standard as it's written, he pled guilty. That alone, there's the next thing that I think we want to find, and it runs akin to the wrongful conviction statute.
He claims he
Get
pled.
back to my point, he pled guilty to something that isn't a crime. We have a law, the Iowa law prohibits soliciting someone to do a criminal act. The charge here that he pled guilty to was soliciting a minor to commit a sex act. The person wasn't a minor, but even if they had been, the minor wouldn't have been committing a crime. There is no such crime, right?
Well, I think it's easy to package it that way, Your Honor. I do, but I think in the actual throes of this is what Mr. McGee and then ultimately Mr. Capotosto were faced with, and that is he's got some outside jurisdictions that were cited to by the district court that interpreted this statute or a very similar statute the other way. And so when he's counseling his client, he can't say, I can guarantee you we're not going to be convicted.
But that goes to breach of duty, and that goes to causation. Those are jury issues. I mean, you want to take all the jury issues away and protect the lawyer with this actual innocence thing. I mean, why should a lawyer get these special protections when no other professionals get these protections?
Well, two things. Number one, I think, as my brief cited, we provide these protections in professional malpractice cases when the facts don't meet that threshold. We do it all the time. But secondly, and
Tell me in other professions where we have this threshold. Accounting, medical malpractice, nursing, all these professions. Tell me where we have these thresholds, these artificial thresholds, which prevent somebody from recovering.
well, we have, and the reason we're asking for it, Justice, is in this case, what we have is a whole different scrutinizing in a PCR proceeding that other professionals don't have either. And so what I'm suggesting is the scrutiny in a PCR proceeding, insofar as the conduct, the ineffective conduct, our court bends over backwards to lean the other way. In other words, we want the system to definitely work for folks. But if we're going to scrutinize the ineffective assistance of counsel, I think we then need to suggest in these type of professional malpractice proceedings, we need to equally scrutinize the wrongful conduct of those defendants.
A professional malpractice case involving lawyers generally, do we scrutinize the moral blameworthiness of the client? In a professional negligence case involving a physician, do we look into the moral blameworthiness of the patient? I mean, it seems to me we don't. Correct me if I'm wrong. I may have missed something, but
No.
but ordinarily we don't. We do insist, I think, on a breach of duty, and we do insist on adequate causation now under Restatement Third. I mean, I understand what I hear you saying, and I invite you to correct me, but you're kind of saying, hey, look, it's unfair to drag my clients into a potentially protracted litigation
Already
setting.
protracted.
But my question to you is, don't we do that across the board in professional malpractice cases generally? And then, why are we getting special treatment here for this setting?
Well, it's not, again, I don't think it's special treatment. We're implicating a case within a case. The underlying case implicates criminal conduct.
Isn't that a summary judgment question? I mean, maybe you can win on summary judgment, I really don't know, and but if there's causation, if there's no causation, if the plaintiff can't show some kind of tangible harm,
Sure.
you get zeroed out, or maybe a judge gives you summary judgment. But don't they get that far, at least?
Well, I don't think so because, we cited the Cole versus Taylor case. In order to prove this case, again, he wasn't committed to jail because of the plea. The exact opposite. He was committed to jail because he had 5 probation revocation hearings.
And I agree. If this fellow walked into my office with this case when I was in practice, this might not have been, the top case on my list to accept.
Problem is, I would have taken it.
But having said that, what do you make of the fact that the restatement of law governing lawyers, and we follow the restatement a fair amount of time here in Iowa, rejects the actual innocence requirement?
I think it's rejected for this reason, and I've read way more on this than I've ever wanted, and that is one of the questions we had earlier. It's impossible to fashion an actual innocence rule that's going to catch everything. So I think that's been the reason folks when courts aren't wanting to try to do that, because you can always come up with a bizarre scenario or any kind of a scenario on these outer edges that maybe you could say, well, this isn't going to apply for that reason.
If we make it easier to sue criminal defense lawyers, is that going to scare people off from taking on these cases?
Absolutely, and I think more so in cases of a plea, and that's all I'm asking for. I think when you plea, it's similar, it's akin to the wrongful incarceration, but
Seems counterintuitive to tort law. When you make someone responsible for their negligent act as a professional, it's a deterrent from them to make sure they do their job right. I mean, if someone wants to not take a case because they don't want to do their job right, that sounds ridiculous. I mean, medical malpractice, accounting malpractice, all of it raises the standard of care. And malpractice against lawyers raises the standard of care. So if someone wants to scare it off, that's fine if they don't know what they're doing. But how can you say it's going to scare people off from taking cases?
Well,
What empirical evidence do you have of that?
Sure. This case, think of it this way. This statute that Mr. McGee had, there was no interpretation from this court, and I appreciate, Justice Mansfield, your discussion about it, but he had no discussion, so he had to go to outside jurisdictions. He can't tell his client without...
Well, did he try reading the language of the statute?
Well, he did, and you know what? He went to some outside jurisdictions, which was the best they had. And the judge in the district court, first off, permitted the amendment, right? Permitted them to amend to bring that charge and said expressly there's a factual basis in the minutes for it. And then later they accepted the plea, and the colloquy was, I find there's a factual basis for this plea.
So that's a great jury argument, and that's a great, summary judgment argument. But you're trying to stop this off before all those arguments are made, and we don't do that in any other profession.
Well, I think we're asking you to uphold the summary judgment, and I think we can do that on any matter. That's what we were granted with summary judgment here, and I think I don't disagree with you, and I've thought that through a lot, Justice, and certainly would be urging that if we ended up in a trial.
Counsel, a lot of the questions certainly reveal that there's a lot of policy considerations flying around here. What do we give any consideration to the existence of the actual innocent standard in the wrongful conviction statute that was enacted across the street?
I think we do, and I know we noted that in our brief, but absolutely, and that's where we have some direction from the legislature. And similarly, that's why I say, he says the system failed me. This person wasn't innocent, and more so, he pled guilty. You have all your reasons for it, but that's in the wrongful incarceration statute too. You don't get to plead guilty because you are guilty of a crime, have no jail time, and then come back around because of all your other wrongful conduct, and that's where we cited Cole versus Taylor. He has to rely on his wrongful conduct in continuing to solicit folks online, continuing to look at child pornography. He has to rely on that. I want to leave. I'm sorry, Don, I didn't leave you any time, so unless there's anything immediately. A couple minutes, I'm sorry.
Mr. Capotosto, we'll give you 5 minutes.
Please, court, counsel, Mr. Wonio. Just listening to what has been said up to this point, and your most recent series of questions regarding the comparison with the wrongful imprisonment statute. I would say this, that it's not unusual for say a legislature to craft legislation after the court here has made a common law ruling and thus changed the law. I would recite or refer to, at risk of going against the master here, mentioning the comparative negligence ruling that eventually then led to some additional legislation to fine-tune and clarify how the law would be applied here. By the same token, there's nothing that should prevent this court from looking at legislation that's already been passed, in this case the wrongful imprisonment statute, and asking itself, well, should there be a totally two levels of jurisprudence for one type of case that just happens to be a claim for money against the state, and a different one?
There is all the time, though. If you read the immunity statute, the state has immunity for not ice and snow if they follow the policy. A private person does it. The state has immunity for following standards. A private person doesn't. I mean, the state has done all kinds of immunities in the State Torts Claim Act, which are different than for private people. And they do that because of the immunity and some other policy reasons. But how can you say blanketly that the legislature passes the law to protect the state, the public fisc, should also protect a private lawyer if and when they're negligent?
Well, I guess the question is, should there be, because we are talking about a common law rule here. The actual innocence rule is a common law rule that is directly dovetails with the wrongful imprisonment theory. Yes, I understand that the legislature can do whatever it wants. I guess the question is, should the standard for those that are not within the ambit of Section 6 or Chapter 663A be so diametrically different?
Let me ask this question, if I may, and I haven't looked at all the cases, but looked at a number of them. The suggestion is made that even in those states that do apply some kind of actual innocence rule, that you're going further than a lot of the cases. The suggestion is, for instance, in California, I believe, there is an actual innocence rule of a type, but you have to show that you're actually innocent of the crimes charged. But it limits it, as I read I think it's a Wilkinson case, it limits it to crimes charged.
Well, Your Honor, if I think if you look to the, am I over time?
But please,
No, you have a couple minutes.
Did I? Okay, thank you, Your Honor. If you look at those California cases, they went in a series progressively through the point until finally the last case was all transactionally related offenses, which is what the judge in our case adopted in his ruling on summary judgment motion. And so
don't most of the cases fall short of that?
I will agree with that. Most do fall short of that.
What's your policy reason then, for advocating the fairly robust version of actual innocence?
Well, in effect, there's the same policy reasons that were recited in Trobaugh, which stopped just short of walking through the door, and I guess right now you're being asked to walk through the door. Thank you, Your Honors.
Thank you as well, Counsel. Rebuttal?
Your Honors, if I may quickly correct some discussion about the Wilkinson case that counsel just stated. Our district court was requiring Mr. Barker and would require all criminal malpractice plaintiffs to prove actual innocence of any crime of which they were charged. It was a transactional offense, and this was just a crime charged. It was dropped. He was not adjudicated guilty of that charge. In Wilkinson versus Zeeland, the criminal malpractice plaintiff had actually been convicted of 3 crimes. She only received post-conviction exoneration on 1 of those crimes. All the additional 2 still stood. She did not receive post-conviction exoneration on those. And the Court of Appeals in California said that she had to prove actual innocence of all of those transactionally related offenses of which she had been adjudicated guilty. We obviously do not have that here. That opens the door to questions about how far does this transactionally related requirement span? Does it span to all of the charges that were brought? Does it span beyond that to any charge that could have been brought? Does it factor in that prosecutorial discretion in charging?
Would you be all right with a standard that required you to prove actual innocence of the crime of which the client was actually convicted?
Your Honor, I think, first of all, we wouldn't be okay, per se, with any actual innocence requirement for the reasons stated earlier based on policy and because it is effectively dealt with in the causation analysis. But to the extent, yes, that element was adopted by this court, it would be prudent to limit it to the crime of which the criminal malpractice plaintiff was convicted, was exonerated, and is now seeking recovery.
In a sense, I guess maybe you can get relief if we decline to go with kind of full-throated transactional actual innocence.
I'm sorry, could you repeat the question?
I guess you claim you'd be entitled to relief if we decline to go with what I would call full-throated transactional actual innocence.
If it was actual innocence of crimes of which there had been a guilty plea, yes, Mr. Barker would surpass the actual innocence requirement and then be permitted to present his case to the jury.
About the deterrence issue, I think I sensed, and certainly in the briefing and to some extent in oral argument, there's concern about expressed about defense lawyers and willingness to represent clients under difficult circumstances, huge caseloads, moderate compensation, or maybe less than moderate, I don't know. But the point is, there's a public policy, I take it, in encouraging public defense. Please respond.
Indeed, Your Honor. And that is a laudable goal, of course. There is no empirical evidence to date, however, that there has been any sort of a chilling effect on criminal defense in any of the 7 other jurisdictions that have rejected the actual innocence standard. And that's particularly in states such as Indiana and Ohio, where they have completely rejected actual innocence or post-conviction exoneration. We would expect to see that type of a chill come into effect, and we have not. Furthermore, any interest in encouraging criminal representation is truly void without an equally strong interest in ensuring that the representation is at a minimum not negligent. And that is a part of the greatest policy argument that I see here. Criminal defendants have a constitutional right to effective assistance of counsel, and that should be the ultimate public policy that guides this court. A guilty defendant is entitled to the same adequate representation as an innocent defendant. Essentially, an attorney who knows that his client is guilty of something would be able to pass any cognizable duty to act competently towards that client. This court should be more concerned with ensuring this fundamental right versus protecting defense lawyers. One of the courts said, it is of utmost importance that the court seek to protect the public from the lawyer's misdeeds rather than the other way around. And we think that that is telling. Your Honors, for these reasons, we request that the court, as with the Kansas Supreme Court in the recently decided Mashaney decision, reject the actual innocence requirement, reverse the ruling of the district court, and remand the case for trial. Thank you.
Thank you as well, counsel. The Barker matter is submitted, and we'll now hear arguments in the Lee case.